I'm Ben Meiselas from Legal AF, joined, of course, by Michael Popok. We're going to be talking about a lot of very horrific Supreme Court decisions today, and it's unfortunate that we have to report on this bad news. But if you've been following Legal AF, we've unfortunately been predicting all of these various cases, what the outcomes were going to be based on the composition of the court. The first case that we want to talk about, or we have to talk about, involves the right-wing Supreme Court striking down President Biden's student debt relief program that was implemented through the Department of Education, where individuals who were earning less than $125,000 or a combined household of $250,000 could qualify or would qualify for student debt relief of anywhere between $10,000 to $20,000, depending on the specific type of loan at issue. MAGA Republican AstroTurf groups challenged this across the country and finally found various courts to get this all the way up to the Supreme Court. There were two main cases before the United States Supreme Court. One was titled Biden versus Nebraska. The other case was titled Department of Education versus Brown. In Biden versus Nebraska, the individuals suing the Biden administration were actually not individuals, they were states, including Nebraska, Missouri, and several other states led by Republicans, where Republican attorney generals initiated lawsuits. The Department of Education versus Brown case was brought by an AstroTurfed group in the name of individuals who purported to be students who were upset that they were only getting partial debt relief and not full debt relief. One person was getting $10,000, not $20,000, and one person had private loans and said they would not be benefited under this. So both of these cases eventually worked their way up to the Supreme Court. Work their way up is probably a generous way of phrasing it. The Supreme Court kind of sucked them up very, very, very quickly based on the procedural posture of this, heard oral arguments based on the emergency nature by which the student debt relief program had to be implemented. And ultimately, on Friday, the Supreme Court in the Biden v. Nebraska case struck down Biden's student debt relief program. And first in the analysis found there to be standing based on Missouri's relationship to this public corporation controlled by the state of Missouri that claimed it would lose about $44 million if students had if they had student debt relief. The court did not find standing in the Department of Education v. Brown case. That case was dismissed. And then the court went on to an analysis that Popok will talk about in Biden versus Nebraska, basically finding that it violated the separation of powers and struck it down. I vehemently disagree with the ruling. It was a 6-3 decision. The 6 right-wing members voted to strike it down. The 3 Democratic appointees to the bench would have kept it in place. But Popok, why don't you break down what went down?
Yeah, if you hated the Dobbs decision last year, you're going to hate all of the things we're going to talk about on these various hot takes, starting with the debt relief program. Justice Roberts, not to be outdone by Alito, who seems to be, up till now, had been writing all of the really terrible, super right-wing decisions. Roberts, Chief Justice, stepped in and wrote this decision. He found that under the Title IV powers of the Secretary of Education, he believes that the Secretary of Education under Biden has overstepped his authority, that instead of just modifying or waiving certain aspects of the student loan program, as was permitted both under the original Title IV when it was passed in 1965, and then later amended right after the World Trade Center attack and then in 2003 creating the HEROES Act, that he overstepped his authority, that the power to modify or waive is not the power, in their view, in the right-wing view, to cancel an entire program at $430 billion worth of debt. And that if Congress, this is Roberts' analysis, if Congress wanted the secretary to do that, they would have had to express that specifically in the legislation, and that this major decision, to use the major decision doctrine as a further support for their analysis, the right wing does not believe that Congress, if polled, for instance, today and asked, is it okay for the secretary to waive $430 billion worth of student debt? They think the answer would be no. Whereas the dissent, written by Kagan, supported by Ketanji Brown Jackson and by Sotomayor, said, well, we think if the question was posed to Congress, the question would be yes, that they would have that power, that even Trump's Secretary of Education, Betsy DeVos, suspended payment and for long periods of time because of COVID. The problem for Roberts is that President Biden announced that COVID was over. And so there's this sneaking suspicion that Biden used while it was still around, while COVID was still a pandemic recognized by the government, used it to cancel out all of this debt. We side, of course, with Kagan's analysis in dissent, which basically says the power to modify, the power to waive, means also the power not to leave a Swiss cheese approach to the statute, and that the only way, once you decided that you were not going to allow the borrowers to be in a worse position than they were before the pandemic, would be to cancel their debt outright and let the chips fall where they may. If there is a cost to be incurred, then that was going to be paid by the federal government under Biden's plans. In other words, it wasn't like cancellation of debt and the banks are left going, hey, where's our money? And the various state-run agencies, like the one in Missouri that was found to have standing, are going to be out their fees. They're going to get paid. They're just not going to get paid by the students. They're going to get paid by Joe Biden's programs and by costs being allocated by Congress and by his budget. And so, that's why we never really saw the ultimate problem here. Yes, I would agree that if they're going to impair contracts and they're just going to use their power to go, no more, no one's going to pay this, everybody gets to walk, and then we'd be a little bit more suspect ourselves. But that wasn't the program, and that's not the power of the Secretary of Education. And as the dissent in Kagan so eloquently put it, it's no different under the Trump administration when Betsy DeVos waved a magic wand and modified certain aspects of the program and suspended the application of the program. This just went one step further, recognizing the tremendous harm and the tremendous hole that borrowers were in, to solve it once and for all with those powers. And then the issue, Ben, we'll talk about this throughout, the very strident attack and dialogue. You'll often see in a majority opinion, this one 6-3, written by Roberts, and a concurrence as well by Barrett. Yes, they'll reference the dissent, but the way they reference Kagan and the dissent really shows the enmity that's there, that they, as you and I discussed before, that they don't get along and they don't see eye to eye. And it's getting to be almost not collegial at all between these two warring factions, the 6-3, because he'll reference Kagan and then say, well, how adorable, I'm paraphrasing, how adorable your position is. But that doesn't make, you say that since we support our position with multiple grounds, and we use the major question doctrine as one of those grounds, that means we must have a tell, and he uses her own words against her, that indicates that we're going to depart from our normal construction and interpretation of statutes. We think that having multiple grounds shows the strength of our decision. It's just the snide way, and we'll see it again in the other things we're going to talk about later today, the snide way in which the majority is beating up on the minority, the right, the Democratic wing, if you will, of the Supreme Court. And the result is, let's talk about the real people result. Students that are in major hock and in debt and that have not been able to recover along with the wealthiest in our society after COVID and are still suffering, unless Joe Biden comes up with a different plan, and looks like he's going to, are now stuck having to repay loans that they can't repay. And if they're repaying loans, they're not doing something else with it, like healthcare, rent, food, medical, supporting family members, and the like.
And look, PPP loans given almost indiscriminately to, in many cases, very wealthy people, those loans forgiven, no questions asked, forgiven loans, bailouts to billionaires, bailouts to decamillionaires, bailouts to millionaires and hedge funds and venture capitalists. We hear about that happening all the time. But President Biden had a different priority, and he's talked about it in Bidenomics, right? He's talked bottom up, middle up economics and focused on workers. That's why this was very targeted. It wasn't indiscriminate. It wasn't like PPP where, hey, if you know a banker, just apply and just pick a number basically and we'll give it to you, right? That's indiscriminate. Biden's like, no. We're focused on people who are making less than $125,000. And most of this would actually help lower income people by and large. So it's not a both sides issue, number one. Number two, when people say, well, it got struck down under the Biden administration. No, look, elections have consequences. There are 9 justices on the Supreme Court. Donald Trump appointed 3 of them. George W. Bush appointed 2 of the others. One other is a legacy from George H.W. Bush. And you have a 6-3 Supreme Court. And the 6 are very radical and very extreme people. And as we talk about some of these other orders that they issued, they frankly believe in a kind of Christian religious led guns everywhere types of place. Women be controlled by men, discrimination on the basis of religion, and on the pretext of free speech is okay. That is what is generally going on here. And look, if you look directly at just the language of the HEROES Act, like to me, and Popok, your analysis is spot on. This is a very simple case, right? The secretary invoked the Higher Education Relief Opportunities for Students Act, the HEROES Act, which authorized the secretary to waive or modify any provision applicable to federal student financial assistance programs as may be necessary to ensure that recipients of student financial assistance are no worse financially in relation to that financial assistance because of a national emergency or disaster, right? The language is very clear what the power is. COVID is a national emergency. The Secretary of Education invoked those powers. Whether you want to call it a modification or a waiver, as the Biden administration Solicitor General argued, call it a modification, call it a waiver, combine the two. That's pretty freaking expansive on what the power is. And the right-wing Supreme Court goes, well, if Congress back in 2003 didn't specifically delineate the type of emergency, well, now you're creating a whole new regime of law. Really? So Congress in 2003 supposed to legislate on the COVID pandemic in 2019, 2020, and they're into the future. That's how absurd this decision is. And to your point, Michael Popok, who suffers? Students suffer, lower income people suffer. I'll give you the final word.
And the other sharp stick in the eye by Justice Roberts, which we'll talk about as a theme when we tie all these things together later, is one of the bases for him ruling that the text that you read out loud, which even we can sit and listen and know it applies exactly to the power of the secretary to waive, modify, plus, and get rid of the student loan debt and have the government take on that debt. Just to be clear, it's not we're not communists. We're not eliminating debt and sticking the banks and the state agencies without their money. But he went on to say that, you know how we know on the right wing that this was a major decision that should be considered by Congress. Look at the sharp debate that has been generated by the Biden relief program. In other words, the right wing MAGA trolls who are against because they're not getting the benefit of it. They got the benefit, as Ben, you pointed out, the PPP loans and all the other things that were literally a fire hose of congressional money shooting out $100 bills to those that own businesses. I mean, let's be frank, and got waived because they were in distress. We had to save the economy. This was Bidenomics. This is how to save the economy and the little person, the person that is on the other side of the employment relationship. And he pointed to sharp debates, and that's how we know. Really, what about the sharp debates that broke out because of the abortion decision and the Dobbs decision? That did Alito, with his callousness, let's leave it to the states and we'll solve the problem of this constant tension over abortion and we'll let it go to the states. That's where it belongs. The sharp debate there didn't stop them from doing anything. So it really is gaslighting, again, for them to point to a rationale for overturning this policy decision by the President of the United States to help Americans by pointing to the debate, the same debate that they have been completely deaf, dumb, and blind to when it relates to other things that matter to the American people, like a woman's right to choose.
You know, I'll leave you with this last thought, even though I said I was going to throw you the last word, and it goes back to the standing issue. For there to be a lawsuit, there has to be standing. And when the district court judge threw this case out originally, and it was a Republican district court judge out of St. Louis, said there's no standing here. The states don't have standing. And the way the Supreme Court managed to find standing, where frankly it didn't exist, is that there is this entity in Missouri called Mohela, Mohela, and it's an acronym for some public corporation that was originally created by the state of Missouri, but it exists to collect student loans, and it's involved in the student loan business, basically. Mohela itself, the actual entity, didn't file the lawsuit. The state of Missouri said we should have standing through a corporation, and the corporation is not the one even filing the suit. Mohela could have filed the suit if it genuinely thought it was injured, but it didn't. And the Supreme Court found, well, because the state created Mohela, they could then say Mohela is injured, even though Mohela didn't even file the lawsuit anyway. You see where the Supreme Court's going with these decisions and making up excuse after excuse.
Just on that, that'll segue to the other things we're going to do today. Standing seems to be something that has been weaponized by the right wing of the Supreme Court. When they want to issue edicts, and you like to use the phrase, so I'll credit you, the Taliban on the right wing like to issue, for instance, religious edicts. They do so without regard to standing. We were always taught in law school, regardless of when you went to law school, that in order for the Supreme Court, which has limited jurisdictional power, to exercise it, there has to be a live case or controversy in front of it, meaning a real dispute. They didn't used to be in the business of issuing advisory opinions. And they're certainly not in the business, based on our Constitution, in just issuing an edict like, hey, today we'd like to address gun rights. We don't have a case in front of us, but here's the new law. They're not supposed to legislate. But by being ridiculously flexible and stretching standing, finding standing when there really isn't any, because from a policy standpoint, reverse engineering, they want to issue the policy decision to rip away a right, or as you said, not finding standing when the policy decision will be not what they want to accomplish. They've weaponized standing. We'll talk about it more, both in hot takes like this one and on our podcast on Wednesdays and Saturdays, Legal AF.
Make sure you subscribe to Legal AF. New Legal AF Saturday night. We'll be live at 8 Eastern, 5 Pacific. Subscribe to the MeidasTouch Network. Subscribe to Legal AF wherever podcasts are available. Thanks for watching. Hit subscribe.
Hey Midas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.